Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather and Tharp, and you're listening to Merriweather and Tharp Radio on the new Talk 106.7. Here you'll learn about divorce, family law, tips on how to save your marriage if it's in the middle of a crisis, and even from time to time, tips on how to take your marriage to the next level. If you want to learn more about us, you can always call or visit us online at AtlantaDivorceTeam.com.
I got to tell you, the taking off of the glasses was very dramatic. It was, this is Lee and Todd, and we're ready to educate you. That was nicely done.
It's a little different recording today.
It was. It is.
Maybe we should share that now we are putting our video,
Take your time. Don't hurt yourself.
We are taking the radio show,
Audio and video,
to YouTube.
Okay.
And so we're recording it live.
Yes.
But it'll be up on YouTube later. So we're actually not live streaming it.
I was about to say, what does that mean? Of course we're recording it live. I'm not really sure what that meant. We are off to a really not good start.
That's what happens when we shoot from the hip some days.
Okay, we're live while we're recording this, so you're in luck. We're going to breathe. All right.
All right.
But that's not what we are doing a show about.
No, we're not doing about recording radio shows.
No, alive. So what are we going to be talking about today?
The new changes to the child support guidelines here in Georgia.
Yep. We've done shows about child support before, and as with a lot of the topics that we spend time talking about, from time to time we have to revisit. And the reason for that is sometimes just because it's time. It's an important topic, an important issue that needs to be discussed, and sometimes because there have been actual changes in the law.
Yeah.
And so that's really the reason we're doing this show today. There have been relatively recently some changes in the law, and so it's important that we revisit it so that listeners, when they start to educate themselves, they are actually thinking about things based on the current state of the law, all right? And they're using the right tool and applying the right, laws.
Since we are publishing the YouTube after this goes live, we're alive. Never mind.
Moving along.
We probably should make it clear that the law is constantly changing in child support. So you may watch this if you're not listening to it while we're playing it on the air, and you're listening to it sometime after the fact. The law may have changed since we recorded this.
There could be a change while we're doing the show.
That's
true.
How
crazy would that be?
I actually had a case where the judge made a ruling, and I won, and on the way back to my office, I got an emailed order where he changed his ruling because a case had come out in the middle of our trial. And so, and that resulted in him having to, he wasn't trying to be mean or anything. Literally, the new case changed the law.
Did you file a motion for no takesy-backsies? I'm sorry,
Is
Judge.
That new? No, I didn't.
I read about that somewhere.
Oh, okay. Is that a Latin term? Takesy-backsies?
It's takesy-backsies.
Okay.
It is Latin. So, child support. I think a good way to start, let's explain again Georgia child support. Now, the reason I think this is important and why a refresher is a good way to start, even though we've done these shows, even though there's a lot of content online, I can't tell you how many times people will call, and I'll start talking to them, and I'll say, okay, child support, have you given that some thought? And they're like, oh, yeah, I've already run some calculations. I applied 20% of the gross income of the father, so I have a child support number, and I have to say, no, hold on. Pump the brakes a little bit, because what you're doing is applying a law that really hasn't been in effect since 2007. There has been a major change. We now have a calculator, and it's a whole new way, a whole new method of calculating child support. So let's spend this first segment, or at least some portion of it, explaining the law, just generally speaking. So
the law here in Georgia, and there's many states that have converted to this, how they calculate it like this, where it's a income sharing approach, and what they do is they take the income of both parties, they combine that to a combined gross income. Now, there's some states that do net income. That's not what we do here in Georgia. We do a combined gross income, and then that yields a number. So if mom makes $5,000 a month and dad makes $5,000 a month, this is gross before taxes, and you plug that in, it makes $10,000. Then you take it to what's called the Basic Child Support Guidelines, and so the BCSO, and that's actually in the worksheet that's what we don't have anymore is the worksheet we've been doing. That's one of the changes. But in past, there was an Excel spreadsheet, and then so it would take that $10,000 and it would say, and I don't remember what the number is off the top of my head because that sheet is massive. I did not memorize it.
Mm-hmm.
And so it might say, well, for $10,000
combined gross
income with 2 children would be $1,500 a month. I don't know if it's that high, but I don't think it's that high.
No,
but anyways,
I mean,
but so then you would take that, and so since it was 50-50, meaning as far as mom and dad made the same amount, then dad would pay half of that to mom.
Yeah, that you're talking about the pro rata percentage, and the
right.
pro rata percentage is, let's assume, using your example, 5,000, 5,000
mm-hmm.
combined. That's 10,000. Each party's percent, portion of the combined gross is in that case 50%.
Yeah.
If it was, let's say, 6,000 and 4,000, it would be a 60%, 40%, and that pro rata percentage carries along in the child support worksheet, and it applies to the guidelines, and becomes very important. So when we're taking the combined incomes and looking at each person's share or percentage, that percentage it becomes incredibly important. So that's what you're talking about with the pro rata share.
Yes. So,
okay.
And let's say it was $1,000 a month, then you would split it. He would be responsible for 50% of that.
You're applying the pro rata percentage.
Right. 50% of the total number. And now that changes. I mean, so that can go up and down from there. So there's that's sort of the basic level, and then it changes based on who's paying health insurance and dental insurance. And some of these are mandatory changes. Some of them are at the discretion of the court. And so you also have, what's the other? There's so many.
Well, you have low income deviations, high income deviations.
Well, another mandatory one is child care. So
child care, right.
So child care related to
work.
Yes. And so that goes in. That's mandatory.
Yep.
So that goes in there. Now, you may not have. So let's say there isn't child care, but you've got extracurricular activities. That's discretionary. So meaning the court does not have to put it in there. And
right.
There's a portion of the child support that is presumed to go towards the extracurricular activities, and it's something like 7.5%.
It's something. It's 7. It's about 7%. You're right.
Yeah.
And so what that means, just to clarify a little bit, because we'll have people, they'll call and they'll say, well, hold on one second. Yes, I'm getting the general child support, but what about activity costs? What about, the soccer, or what about, whatever it might be? And what we have to explain is that there's already built into that child support number,
mm-hmm.
about 7-point-something% of that number is supposed to be used by the custodial parent, the one who is receiving child support, to pay for some of those expenses. Now, if the expenses exceed, then that's one thing that can be brought to the court's attention, and an additional deviation upwards could be requested in order to help pay the costs of those expenses.
And then there's also upward deviations because that BCSO, the child support chart, it stops at $30,000.
Yeah.
And so once you hit that, it doesn't keep going, but then the court can make a discretionary call and award more child support for someone that makes more than, when you have a situation where the combined gross income is more than $30,000 a month.
Right.
And we had a show talking about that where
people were asking for ridiculous amounts.
$60,000 a month.
$100,000,
in child support a month.
Yeah, a month.
Yeah. That's
makes you want to go out and have a child with somebody very wealthy. I love you, honey, but
we're just kidding.
Yeah. So look, child support, the income share model, very different than what it used to be.
Mm-hmm.
All right. And the good thing about it is it's very formulaic. The old way of calculating it, there was a percent range and you would apply it to the gross income. Here, everything, it's a big formula. You take gross income, plug in some other data, and it's going to spit out a number. All right? It's going to tell you what child support should be.
Yes.
And actually, it's not what it should be. if there's not a valid discretionary or
Reason.
required deviation, then the court must follow the guidelines. The court must accept that number and will demand that the numbers are correct. In other words, if it says child support's $1,000 and you and your spouse look at each other and you're like, well, just pay me $800. No, court's going to look at you and say, unless there's a valid deviation, it's $1,000. Okay, that's the legal requirement.
Yeah, and I've been in court when judges rejected a settlement proposal that did not follow the guidelines. So there wasn't a valid basis for the deviation, and the court rejected the settlement proposal, and the parties had to go back to the negotiation table.
Yep.
So, all right. Well, up next, we're going to get into what actually changed with the child support guidelines and how it's different now and how those changes can impact several people that are going through the child support system trying to get child support. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather & Tharp, and you're listening to Merriweather & Tharp Radio on the new Talk 1067. We today are talking about child support changes. And by the way, if you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. But we're going into the recent changes, child support guidelines. They came out, most of the changes came out in July. And then there's one change that just occurred September 30th. So not too long, or just a few days ago. And we're going to just rapid fire talk about them. We're just going to give a short summary, and then we're going to dive a little deeper in what they could mean for people that are trying to get child support. So, all right. So allowance for multiple worksheets is one of them. Final rule language added. I'm like, what is the final rule? Changes to imputed income, health insurance clarification, and additional considerations regarding deviations. That's it.
We're done.
We're done.
Yeah.
Todd, maybe you should explain what those are.
Yeah, all right. Well, we do have some time. So, all right, let's talk first about the use of multiple worksheets. And let me start by explaining what a worksheet is. Because we're talking about, again, we in the first segment talked about the methodology behind calculating child support. So understand that what's been created as part of the Georgia child support calculation is a worksheet. So as you plug the information in, it automatically populates into a worksheet, and there are different, basically, exhibits to that worksheet, different parts, A, B, D, and E. And so that worksheet is going to have all of the information that you've plugged in, and it's going to then calculate for you the child support amount. So typically in a case, you are going to present the court with one worksheet. You are going to determine based on whatever the factors are. If you have two children, doesn't matter how old they are, when they are going to be emancipated, you're going to create one worksheet. It's going to basically create a child support obligation, and then basically you're done. And if you have to come back and modify, that's what you do. You know, if one child is emancipated, graduates from high school, and then it's only one child, you're going to come back. Another worksheet would be created at that point, and you would have a new child support number based on one child. So now what we're talking about is, instead of just presenting the court with one worksheet, you can actually, under certain specific circumstances, you can actually present the court with multiple worksheets to reflect basically changes that might occur in the future. And basically that's what we're talking about.
And the limit was, I think, like if you had someone that was about to age out, like within 2 years. And in the past, like what you said, you could only do one. Well, if the parties were in agreement, you could do multiple worksheets.
Yeah.
And I'd never had a judge turn that down. But if the parties weren't in agreement, the judge only did one worksheet, even if there was a child that was 16 years old or 17 years old. And so in a year, that meant that the obligor, the person paying child support, was going to have to come back to court to modify the child support when that child aged out. And in Georgia, that's 18, or when they graduate from high school, with a cap of 20 in case they have to stay in high school a little bit longer or they've been held back.
And that's a burden for the person. That's a burden for the court. That's, like you said, there are times, and I've had those situations also, where by agreement we know that there's going to be a change forthcoming, and we say, okay, well, this is the child support worksheet when it's 2 children, but guess what? In a year, this child is going to graduate. So instead of having to come back, here's another
Let's
set.
save everybody money and hassle.
That's
and
right.
Let's deal with it.
Let's just
right
deal with
now.
it now. So now the law actually recognizes it,
Yeah.
as opposed to before it was just a practice, meaning attorneys would do it when
by agreement.
by agreement. Now it's basically reflected within the law, and there is recognition that, hey, that makes sense because it's going to help people reach agreements, or it's at the very least going to help the court limit the number of cases and the number of times a case has to come back to court.
And there had been a previous change to this one where they allowed multiple worksheets, but it was kind of confusing and caused problems with the courts. They weren't quite sure what they meant. So the legislature came back out and said, all right, we're going to clarify all this. So you may have a situation where you've got a 14 and a 16-year-old. And so in those situations, it's permitted for the court to say, I'm just going to do 2 worksheets so y'all don't have to come back in a year. But I think that was the limiting factor was that it had to be within 2 years.
Yeah, and I think it's also important to note that what we were talking about just a moment ago is doing this to avoid the need for a modification, all right, incurring the cost, the time, the effort. But that doesn't preclude you from coming back to court to modify. I mean, the door is still open for modification. But again, if you lock in based on certain circumstances, it may limit or to some degree interfere with modification efforts. But again, there is not like a blanket preclusion from ever coming back to court if there are changes of circumstance.
Yeah, and the court actually does have they can reject it. You can still come to court with those multiple worksheets.
Yeah,
but it's within the court's discretion to accept or deny them, because there may be situations where in the middle of the divorce somebody lost their job and the court's going to be like, well, I'll do the worksheets now, but I'm only going to do one because I'm thinking in a year the person who's the obligor is going to get his job back or her job.
Yeah.
All right, so let's go into the final rule.
Dun, dun, dun.
So really what the final rule is, so part of the reasons for the changes in child support guidelines in Georgia was the federal government was trying to get some sort of, I don't know if parity is the right word, but they were trying to get some similarity.
Adoption of a single law that would apply throughout the land.
Right, but they can't force that on people because, well...
It's a state-specific issue.
Right. So we won't get into constitutional law and all that, the Establishment Clause or that's a whole nother
show, not just episode of this show. I mean, different channel
that's a common
show.
Law show.
Right, exactly.
Constitutional law. All right, so what they did was there's a Federal Office of Child Support Enforcement, and they want the courts to sort of they want the courts to keep analyzing the current child support guidelines and update them and change them, and based on changes of, the basic child support obligation chart, that thing changes from time to time. They change the numbers. If the economy changes, those numbers can change. So what they think the average person of a certain income level spends for the support of a child. So those things are changed, but what the Office of Child Support Enforcement specifically wanted in there was the ability, the court needed to analyze the ability of the non-custodial parent, so the parent that did not have the children the majority of the time, the ability of them to pay child support. Because in the past, the court did not have to look at that at all. And I'm not even sure there was actually room for the court to look at it.
I don't think it's not a matter of they didn't have to.
They
didn't.
Yeah.
The requirement did not call for any information to be provided regarding the budget and the ability to pay of the obligor. So now what it is the federal government saying, well, hold on one second. How realistic is that? Mm-hmm. Someone is obligated to pay, and you're not looking at whether or not there are reasonable expenses that person is incurring that might make it so that, hey, they have a job, that's great, but they're living in an alley somewhere because they can't afford a home.
Yeah, and so they don't want the children to be with one parent living in a nice home or a nice apartment, and then going to visit the other parent in a cardboard box. So they said, all right, you've got to look at the obligor's ability to pay, because there are situations where the person, perhaps they've received disability and they really do have serious medical conditions, and those, between their housing costs and their trips to the doctor, there's barely enough money to buy groceries. And if they had to write a check, even $100 a month to the custodial parent for child support, that could put them,
in a bad place.
In a bad place where they couldn't afford food. And they couldn't even afford food when the children came over to visit with them. And so, being the federal Office of Child Enforcement, they're like, well, we don't want to be putting people in jail that are behind because they're trying to stay alive. So they told the Georgia, or basically said to the legislature, you've got to analyze this. And so they put in a rule that the court shall consider the basic subsistence needs of the parents. So it's an obligation of the court. It's not discretionary.
Yeah, and again, it makes sense because, what the court wants is, at the end of the day, what the court wants is a child or children to be taken care of.
Right.
Pushing someone financially into basically a no-win situation where they don't have enough money to live, that's not ultimately going to help a child. Mm-hmm. Pushing that person off the proverbial cliff, that's going to hurt that person, which in effect, the ripple effect is it's going to then impact that person's children. All right. So what I actually like the rule, because what it's saying is, come on, let's look at reasonable factors. Let's look at and consider reasonable information to make sure that this is a winning kind of arrangement. And by winning, I mean that everybody involved wins.
And up next, we're going to find out what the courts can do when considering imputing income to someone who doesn't have a job. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orston. Todd and I are partners at the law firm of Merriweather & Tharp, and you're listening to Merriweather & Tharp Radio on the new Talk 106.7. If you want to learn more about us, you can always call or check us out online at AtlantaDivorceTeam.com. Well, today we're talking about child support. Particularly, we're talking about the recent changes in the child support law. There were several changes made this year. Some will impact people dramatically, others not so much. In other situations, it's more a matter of convenience. But, definitely the ability for the court to accept multiple worksheets is a big help if a child's going to age out in a couple years. But one of the things that has always been a hot item is imputed income. So imputed income is where someone, some people, they're just deadbeats. I mean, that's the term. I'm putting this in air quotes right now. They've been heard to say, I'll quit my job and live in a box before I pay you child support. So we've literally had those cases where someone was foolish enough to put that in writing. So what happens is the court has the ability in those situations to say, sir or ma'am, I've seen both, you have the ability, you have the intelligence to go out and earn this much money, and I'm going to put your child support obligation at that. And
imputation is basically the way I like to refer to it. It's a judicial assumption. Mm-hmm. It's basically the court saying, okay, I don't know how much you are earning, or maybe I know you're earning nothing right now, but I am going to now make an assumption that you are either unemployed voluntarily or you are voluntarily underemployed.
Right.
Meaning a doctor who just loves to dance and says, I'm going to make my money dancing on the street, making, $10 a day. And the court can go, you better dance a lot, because I'm going to assume that you are still a doctor, that you could still earn at a doctor's level, and therefore I'm imputing income at a doctor's income.
Right.
All right. So, and imputation is basically to prevent people from trying to take advantage and game the system.
Yeah.
By saying, I am going to avoid a support obligation by limiting or eliminating my income.
Right. And in some situations, you have cases where someone had parents that could support them. So they said, well, I'm not going to work. Or they get remarried.
Or inheritance.
Inheritance.
They inherit and suddenly,
I don't have any income. I'm living in $1 million home, but I don't have any income. And somehow I'm paying for my car that is worth $120,000. But
and if I were a game show host, I would say, survey says, nope.
So, all right. So one of the changes in the child support guidelines was really a clarification what was going on. So in the past, the court just said that the court or the jury could that they could look at reliable evidence of a person's income or ability to earn. And they've changed it and they clarified it greatly. So they've added a lot more very specific things that the court can look at.
Yeah, which before you read off, which again, this list that you're about to read, these are things that attorneys have been arguing in court for a long time.
Right.
Okay, so to people who practice, okay, like us, a lot of this is not new. What it is, it's nice to see it set forth in the law because basically it gets some of the requirements and gets things out of that gray area where it's like, well, what can the court look at? What should the court look at? So basically, I believe that this is sort of a clarification intended to say to the courts and to attorneys and to anybody representing themselves.
Yeah.
And anybody else who's just bored. No, but it's basically saying, okay, here you go. It's not an exhaustive list, but here's a list of things. This is what the court should be looking at when determining issues of imputation.
So here's a list. So it's like look at the parents' assets, like I said, example before, the house, residence, or maybe assets. It could be a retirement account, an inheritance, but their residence, their employment and earning history, their job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers. So that actually is new, employment barriers. And we'll talk about that as well as the criminal record in a second because that was not in there. That's a big change. Record of seeking work as well as the local job market. And I think that clarification is big too because I've seen judges, I don't know if they ignored it per se, but they didn't consider the job market change. The availability of employers willing to hire the parent, prevailing earnings level in the local community, and other relevant background factors in the case. And we're actually going to have someone come on the show here soon, and that's one of his jobs. He's a vocational expert, and he actually gathers all that data so that you can argue that perhaps a parent is underemployed or they're actually making the best they can make. So I'm looking forward to that show. All right.
So going through some of these just very quickly, because like you said, we're going to have a show dedicated to this issue. You know, things like educational attainment and work history and things like that. It cuts both ways. Keep in mind, this is not focused only on the payor spouse,
right,
the obligor. Because we are now in a situation where it's an income share model, meaning the income of both parties is considered, then imputation can work both ways.
Right.
And sometimes, a lot of times, we'll see this with someone who is a stay-at-home mom, where kids are now 10, 11, 12 years old. They have a PhD. They worked. They made a good amount of money. And they're like, well, no, my kids need me, and I need to be home.
Right.
Under certain circumstances, maybe the court will accept that. We've had cases where it's like, yes, you are needed at home focusing on the kids. There are other times, and there are other judges, where the court may not accept that and may say, you know what, based on your education, based on your work experience, you can and should be out there working.
Right.
Because keep in mind, going back to the child support calculation, if you're not working, then it can really impact dramatically the child support calculation because we were talking about a 5,000 combined 10,000, and it's a 50% pro rata share that gets applied. Well, what happens if you have no income? Then it's a 100 to 0%, and that $1,000 where the payor would have paid 500 or 50%. In that situation where it's 100%, they're paying $1,000. It's
Although
a
the
doubling.
the number will go down. Remember, because
Well, you are correct.
we went from
if it's
$10,000 a month to
you're right.
$5,000
You're
a
right.
month.
If it's a $5,000, you're right. If that
Yeah.
income doesn't change, then the number will be different because it's a combined gross of 5,
Right,
not 10.
but now you're paying 100% of the
But you're paying
obligation.
100% of that. And I've
Yeah.
actually seen situations where maybe the income wouldn't have been that great anyway,
Mm-hmm.
and then you do the calculation, and going from 50-50 or 60-40 down to 0 or maybe a 10%,
Right.
90%, even though the combined gross is lower, they're still paying more than if they had shared at the higher level.
Yes. Yeah. So every situation is a little bit different, but so that is that's been a big change. And one of the other big changes, the one that would mentioned criminal law,
Yeah,
is
the barriers.
So now, so years past, if you were, here's a good example. There was actually a case law on this. There was a Georgia Supreme Court case that said that if you have gotten a DUI and so you are now in jail, that you cannot seek a modification of child support because even though you're not earning income, they said that was a voluntary loss of your job because you voluntarily drank the alcohol, got in the car, and got the DUI. So no, you're not going to get a...
You can't use it as a material change of circumstance.
Right. And now the code says that if a parent is incarcerated, the court shall not, so it's not even discretionary, shall not assume an ability for earning capacity based on the pre-incarceration, so before they went to jail, wages or other employment-related income. So now the courts are saying, no, we can't. If they get a DUI and they lose their job, or it happens in the middle of the divorce case, they get a DUI and lose their job, and they're now in jail, the court's like, well, I know I can see both sides of the argument. It's really rough because on one end, you've got, somebody who is irresponsible, misbehaving, but they can't make any money. They're in jail. They lost their job. They're not earning anything to pay child support.
Yeah, you use the doctor for an example who, forget about wanting to not be a doctor and dance, but let's assume the doctor gets into some legal trouble and
loses his medical license.
A medical license. That is a barrier to earning money at the level of a physician. And so therefore the court can and actually shall keep that in mind and take that into consideration because look, the reality is that person can no longer pay at that level. And
that's an employment barrier because he doesn't have his medical license anymore.
But before we go to the break, I'm going to say one thing. Keep in mind that's not the end of the analysis because if that doctor has $5 million sitting in an account and is like, I can't be a doctor anymore, my child support should reflect that. The court can also say, but hold on one second. You have a whole bunch of money over here. So therefore, no, we're not going to cut it down to 0 because your income is 0. We're going to look at those other assets.
And I've even seen situations where somebody had a huge retirement account, and the court did a child support qualified domestic relations order and took out a lump sum child support out of that person's retirement account. Hey, up next, we're going to dive into the other changes to the new child support guidelines. Welcome, everyone. I'm Lee Merriweather, and with me is Todd Orson. Todd and I are partners at the law firm of Merriweather & Tharp, and you're listening to Merriweather & Tharp Radio on the new Talk 106.7. And this whole show, we've been talking about child support, particularly the changes that recently occurred to the child support guidelines. And I think at the end of the last segment, I said the new child support guidelines. They haven't been new. It was 11 years ago they were new. So, but they're made new almost every year. It seems like there's tweaks and constant changes. And so we've been diving into them, and we have a few left, and hopefully we can get through them very quickly not because they're not important, but they're not as big as the ones we first started off with, because we're going to do a couple hypotheticals.
Are you saying I talk too much? I mean, is that really what you're trying to say? Are you saying
trying not to say it? I'm glad you said it, though. No, I think I'm the problem. All right. Well, I think one of the biggest things that came out of this was, in the past, the child support guidelines said the court has to take into consideration what's in the best interest of the children.
That was the standard.
Like, at the end of the day, if the court's trying to decide whether to deviate from the basic child support obligation, what is in the best interest of the child that was the standard. That's no longer the standard. The standard is for a deviation. Okay, this is changing from the basic child support obligation. The standard is looking at the parent's relative ability and inability to pay the presumptive amount of child support. And that has to be the basis for the deviation.
And that goes into what we were talking about before, where the court shall consider all these other factors relating to the actual ability of the parent to pay. Because, again, if you're focused only on, or if the focus is on the best interest of a child, well, obviously more money, hopefully less problems, you know, more activities and clothes and food and whatever. So if you're going to just say, you know, what's in a child's best interest, well, more money would probably help the child. But now the court is basically saying, well, hold on one second. Obviously, we want to take care of a child and children, but we can't ignore the actual ability of the parent to pay.
And there was a, I want to say maybe 3-4 years ago, there was a class action lawsuit. I think it got dismissed, but it was basically all the fathers that kept getting put in jail, and you know there was a child support amount levied against them that they couldn't pay to begin with. They immediately fell behind. These weren't deadbeat dads. These were dads that wanted to pay their child support, but the court just kept throwing them in jail. So they'd get a job, they start paying, they get pulled in for contempt. Well, you're still behind, you're going to jail. Then they'd lose that job. So these new guidelines are saying, hey, the court's got to take into consideration the ability of this parent to actually pay, because the process of throwing them in jail made things worse. All right, so that's that. And the other quick changes were the changes to the health insurance requirement that is in there that allows parents to now use Medicaid or Peach Care to satisfy the health care needs of the child, because the court could mandate that. And the court continues to have the discretion to order that either or both parents obtain a separate health insurance policies for the children. And then there's the low-income deviations. We kind of already talked about that gets a little more specific, and that the court may consider the non-custodial parent's basic subsistence needs and all of his or her reasonable expenses.
Which, again, that's a huge turnaround when dealing with child support, because I can tell you that the advice that we gave forever was your budget really doesn't mean anything.
Yeah.
And now we have to start saying your budget may mean everything.
Yeah.
All right.
Now I want to put a cautionary tale there. That doesn't mean that you can go around driving, say, well, my mortgage is $4,000 a month. My car payment for my brand new Porsche is $1,500 a month. You know, I've got a clothing allowance. You can't. The court will say that's not reasonable.
Well, and that's. The focus should be on the word may, or words may consider.
Yes.
We're not saying that, well, look, my fourth Porsche, I got to tell you, it's just my costs are through the roof. That's not reasonable, like you said. So the court will consider it, and will consider it to be a ridiculous position to take.
Yeah.
But it's what may or can the court consider when determining these child support amounts, and whether a deviation is reasonable. And so as long as you have a reasonable car payment, reasonable house payment, reasonable everything, you can show the court, Judge, look at my budget. I'm not doing anything unreasonable.
I have to have a car to get to work.
Yeah.
I have to have a house for when the kids come see me.
And at the end of the month, I don't have two nickels to rub together, and you're telling me that I should pay basically $300 or $400 more than I think I can pay. Okay, fine. Just tell me when I can check into jail.
Right.
So anyway, all right. Let's get to an example. Let's talk first very quickly about, and make sure that we're clear that there is now an online worksheet.
Right. So in the past, there was an Excel spreadsheet that you could download from the child support office here in Georgia, but they've done away with that. I don't remember the exact reason, but I think we know someone that we can bring on the show that will explain it to us. That'll be another show. But starting September 30th of 2018, all litigants must present their child support worksheets to the court via the new online worksheets. And they're located, I don't know if I can read this. So I think the website is csconlinecalc, CALC.georgiacourts.gov. And so if you go there, that'll get you to the
And call us if you can't find it.
Right, or if
we
you have
can
trouble.
very quickly give you the address so that you can get to it. And if I had to make an assumption, it's probably that there have been numerous versions because we've dealt with this where we go to court and we start to crunch the numbers or we present our worksheets and the other party is like, well, my numbers are different. And then we look and we're like, well, yeah, your version is from like 3 years ago. It's already been updated like 3 times. And so my guess is this is probably an effort to say, you know what, this is where you get it. And that way you know it's going to be the most updated form and it's going to be accurate.
I do want to do a hypothetical, but before I do, I want to give a couple announcements because if I don't, we're going to run out of time.
Sure.
Happens every time. So if you're enjoying this show, you can actually post a review about us, and the place to do it if you're having trouble like where to post reviews. So we've set up a page on our website to help with that. It's mtlawoffice.com/review it. So that's M as in Mary, T as in Tom, mtlawoffice.com/review it. And if you're interested in watching the show on YouTube, it'll be youtube.com/Atlanta Divorce Lawyer. So you can always find us there too, in case you want to go back and watch part of the show or watch us do our crazy hand motions as we talk. So Todd he's quite animated. So, all right. So let's do a hypothetical before we go.
Sure.
All right. So do we want to do Ron or Tammy? We only have time for one.
You make the call.
All right. Well, I'm going to do Tammy's then.
Well, there you go.
Only because it's a little more interesting. All right.
Since we have about 3 minutes left, yeah, I think you should just make the call.
All right. So we have a divorcing couple. Their name's Ron and Tammy. So Tammy is the director of library services, and she makes $52,500 as a W-2 salaried employee. Tammy and Ron have a relationship full of ups and downs, and Ron can easily get caught up and upset when talking about Tammy. Tammy is known to be vindictive and seems to want to do whatever she can do to bring Ron down. Ron tells you that Ron says that Tammy has always flaunted her sexuality, and he believes that since the separation, Tammy is earning additional income working the internet chat rooms, talking with men, because she has mentioned that she is receiving tokens of affection from various men. Tammy has also bought a bright red Mercedes convertible. You cannot trace the funds toward the purchase of this vehicle from any accounts that have been provided in discovery. You believe that Tammy is hiding money. The base model Mercedes SLC that Tammy is driving is a $48,000 based on your research. So, what do you do? In 1 minute.
Tammy's a little vixen.
So what do you do, Todd?
Go out and buy yourself a Mercedes, right? Isn't that tit for tat? No. All right. So what do you do? Well, obviously, when we're dealing with child support, we have a minute to talk about this. We're going to have to look at what her income is, but then we're going to look at spending. I can tell you right now, we're going to end up looking at credit card statements and bank records and things like that, because you're right. A $48,000 car with that kind of income doesn't make sense.
Right.
Then we have to look to see whether or not there's an argument for imputation.
Yeah.
Is she getting on a regular basis some amount of money from another source that we can ask the court to consider as a part of her income?
Mm-hmm.
If she got a single gift from someone, maybe not. If she gets every year gifts, then maybe so, and imputation then becomes a reality in that case.
So going back to the new child support, the new guidelines, one of the first things this says a parent's assets. So a brand new $48,000 car would be an asset that the court can say, well, I'm going to add $48,000, so your annual gross income is more like $100,000, not $52,000. Well, everyone, thanks so much for listening. That about wraps up this show, and we look forward to talking to you next time.